that are gateway issues. You have to pass through the state action door before you can take up substantive constitutional guarantees. So before you leap to the argument about equal protection or due process or First Amendment or what have you, make sure you're making this claim as against governmental or state action. Okay, now I'd like to turn to substantive constitutional guarantees, and we will start with due process of law. There are two due process clauses in the Constitution, one in the Fifth Amendment applicable against the federal government, and the other in the 14th Amendment applicable against state and local governments. Both employ similar language. They protect all persons from deprivations of life, liberty, or property without due process of law. And we'll talk about three aspects of due process of law: the application of the Bill of Rights to the states through the Due Process Clause of the 14th Amendment, substantive due process, and finally, procedural due process. Now, in starting out, let me observe that the language of the Due Process Clause, by its terms dealing with due process, is plainly about process or procedures. What's not so plain, and in fact is quite controversial, is whether the Due Process Clause also protects certain rights, certain unenumerated constitutional rights, substantive rights, and if it does so, how do we read those rights into the language of the Due Process Clause? To get underneath this, you need to appreciate that there has always been a strain of thinking in our law, that there are fundamental rights which, whether or not they're mentioned in the Constitution, are so fundamental, the basic rights of man, that they are rights that we have against the government and against legislative majorities. Now, in our constitutional democracy, that natural law kind of thinking is pretty controversial. But controversial or not, it's always been around. In the early years of the Republic, the idea of unwritten fundamental rights was sometimes connected up with the Due Process Clause, and the view primarily that due process meant, whatever process it may have meant, also meant freedom from arbitrary government, and in particular interference with vested property rights. Now, probably the most controversial instance of that kind of thinking is represented by the case of Scott versus Sanford, the Dred Scott case, where the Supreme Court held that Congress could not, by legislation, end slavery where it already existed, because the idea was slaves were property, and people could not be divested of property by legislation. That would violate due process of law. The idea that there are these fundamental, though unwritten rights, identifiable by courts, enforceable by courts, became increasingly important after 1868, after the Civil War, and after the 14th Amendment was passed. The 14th Amendment protects the privileges and immunities of national citizenship, equal protection, and due process of law. And after 1868, many people believed that some part of the 14th Amendment, privileges and immunities or the Due Process Clause, was meant to be a shorthand way of applying against the state and local governments the protections of the Bill of Rights. Because prior to 1868, before the passage of the 14th Amendment, the Bill of Rights were held to apply only as against the federal or national government. If you had some free expression issue or some unreasonable search and seek issue against a state or local government, you had to rely on your own state constitution. The Bill of Rights applied only against the federal government. Well, after the 14th Amendment was passed, the court interpreted the Privileges and Immunities Clause under that provision very narrowly, and in effect read it out of the Constitution in a case called the Slaughterhouse Cases. However, the Supreme Court began to hold that some parts of the Bill of Rights were now incorporated against state and local governments because of the Due Process Clause. Now, this whole business about applying the Bill of Rights to the states through the Due Process Clause of the 14th Amendment is known as the incorporation debate, and there are two things you need to know about the incorporation debate. First, strictly as a matter of information, the court has applied what we call selective incorporation. Some Bill of Rights protections apply against state and local governments and others don't. Essentially what the court has asked as to any particular provision, is it fundamental to the American scheme of justice? And over many years and over many decisions, some going this way and some going that and then changing their minds, the following Bill of Rights protections are incorporated against state and local governments. All of the First Amendment, all of the Fourth Amendment, all of the Fifth Amendment, except that part that says that you have to be indicted by a grand jury, all of the Sixth Amendment, but not the Seventh Amendment. The Seventh Amendment guarantees you a right to a trial by jury in a civil case where the amount in controversy is $20 or more. That has not been incorporated. It is not fundamental to our American scheme of justice. The Eighth Amendment has been incorporated. Now the second, whatever you think it means about bearing arms, has not been incorporated. The third, about quartering troops in homes, not the subject of a Supreme Court opinion. We're not much in that business. And the ninth and 10th, which reserves rights to the people or powers to the people in the states respectively, has not thought to be a matter for incorporation. Now, as a technical matter, therefore, let's say you wanted to argue that the state of Illinois was violating your free expression rights. The technical way you would say that is that the state of Illinois was violating your rights of free speech under the First Amendment as applied and incorporated by the Due Process Clause of the 14th Amendment. So that's the first thing you know, what we've done. But the second thing you need to know about the incorporation debate is that underneath it all, it was a debate about unwritten rights and whether the Supreme Court could legitimately and competently identify such rights and protect them as constitutional rights by reading them into the Due Process Clause. Now, on the one hand, you had Justice Black in this debate, who interpreted the language of the Due Process Clause and the history of the Due Process Clause as meaning that the framers meant that all of the Bill of Rights, no more and no less, should be incorporated against the states. He said that judges didn't have any other basis to read rights into the Constitution, and if they tried to do that, that was illegitimate. They were incompetent for trying to do that. It was dangerous. They should stick to the text and to history, which to him meant plainly a complete incorporation, no more, no less. On the other side was Justice Frankfurter, who said that due process, the concept of due process, the words of due process, embodies a general concept of ordered liberty. And we apply the Bill of Rights to the states not through incorporation, but because due process embodies the fundamental protections of rights, which more or less mirror some parts of the Bill of Rights. Now, the court never really resolved this debate. It simply announced that we're going to have selective incorporation. Those rights that, a sufficient number of justices think are fundamental to the American scheme of justice. But there's a point here. The second point about all this is that by so doing, the Supreme Court acknowledged that due process has a substantive content, and at least it includes certain protections of the Bill of Rights. The next big question, though, was whether the Due Process Clause incorporated any other unwritten fundamental rights discoverable by courts and given special protection by them. One candidate, which was quite successful for a time and then died, was the so-called fundamental right of contract. And hence we move into this other area, the general area of substantive due process. Now, substantive due process means nothing other than reading the Due Process Clause as implying that there are fundamental rights that will get special protection by the courts. The first candidate in the modern period, at the turn of the century and continuing into the 1920s and 30s, was the right of contract. It's illustrated best by the case of Lochner versus New York, decided in 1905. In that case, although the court was badly divided, 5-4, the majority struck down a New York law that limited the number of hours an employee of a bakery could work. The employee couldn't work more than 10 hours a day or 60 hours a week. And the court said, reading and interpreting due process of law, substantive due process, it said that due process includes a right that it read into the Constitution now as a right to purchase and sell one's labor, liberty of contract.